there are a lot of issues that happened. The very first one is the issue of a federal high court that on Wednesday granted bail to 12 of the 8 of the popular Yoruba agitator Sunday Igboho, granted them bail after 32 days in DSS custody, and delivering the ruling on the application filed by the 12 applicants before the court. The presiding judge, Justice Igboho, said it is clear that no charge has been brought before the courts against the 8 of Sunday Igboho. He said, as such, the court held that detaining them without charges contravenes the provision of the Administration of Criminal Justice Act and their fundamental human rights. So, fundamental human rights. And among the people who granted bail, 8 of them were granted bail with a sum of 5 million naira, while the remaining 4 was granted the sum of 10 million naira, a like sum. And the person that is going to be standing as surety will have a residence in Abuja. So, gentlemen, 32 days after, I don't know, the DSS.
The State Security Service.
Yes. How would you want to react to this? And what is the position of the law, actually? Looking at when a suspect is arrested, how long is he supposed to be in detention before he's charged to court? And when the suspect is charged to court, how does it take? What are the processes? Is it an issue that has to do with staying this long before you are granted bail?
Well, before I answer your question, let me quickly say that by my own reading of the Constitution and then other instant laws of the country, there is no justification whatsoever to have taken these people to Abuja and arraigned them in a court in Abuja. The people allegedly committed this crime in Ibadan, Oyo State, and if they are supposed to be tried, and if they are supposed to be investigated, Oyo State Federal High Court is the appropriate court, or with the appropriate jurisdiction, to where these people to be tried. When you also look at the Constitution of the Federal Republic of Nigeria, it emphasizes the principle of federalism. And part of our courts, the judicial system, is not outside the ambit of the enforcement and the principle of true federalism. I am aware of the authority that says, look, the Federal High Court, whether sitting in Abuja or Kano and all that, has a jurisdiction to try one single jurisdiction, and that the law confers on them. That's only jurisdiction to try any offense or any offender anywhere in the country. But when you also look at Section 36 of the Constitution of the Federal Republic of Nigeria very, very critically, especially Section 36 sub 6, I think, a B, which says that you should not place difficulties on the part of any suspect or any defendant, then you cannot do what the DSS is doing. You can't. They are supposed to be tried in Ibadan. If it is a federal high court in there they want to use there, because you must make all opportunities and all resources available, all conveniences available for a defendant to be able to put up a very robust defense when he has a case in court. What the DSS has been doing over the years now is to arrest people in one part of the country and take them to Abuja. It's a way of emasculating these people. It's a way of denying them the opportunity to robustly defend themselves. I'll give you an example. Showore, for example, was arrested here in Lagos, taken to Abuja. He doesn't live in Abuja. He doesn't have a house in Abuja. His means of livelihood is in Abuja. His lawyer is based here in Lagos. And then you have marooned him in Abuja now for almost 3 or 2 years.
But is it because of the level of the offense committed?
No, there is
the reason why they are taking.
No, I don't think so, because the federal high court that is trying these Igboho people doesn't have a better jurisdiction than the Oyo State Federal High Court that we do have in Ibadan, India. There is no gravity, no matter how grave a crime might be, that both the Federal High Court in Oyo State and then Abuja could not have tried. It is a deliberate effort by the DSS to emasculate and make life difficult, make it difficult for the defendant to be able to robustly defend themselves, and that is against the law. Look at even Hush Puppy, as grievous as the crime that he has committed when he was arrested, and it was found out that I think California didn't have the jurisdiction. What did they do? They transferred him to another state where they think is a better place there to be tried. You will not even believe it. Immediately he made a plea bargain and then entered the scene and all that. They also asked him, in which prison, in what state would you want to serve your sentence? And he has told them, this is where I would like to serve myself. At the end of the day, Igboho may be brought here to Nigeria if he has elected to serve his prison sentence here in Nigeria, and then he will come and serve it here. And not that. So the truth of the matter is we must all as a people, as a nation, rise up to this executive rascality, this criminality, this irresponsible behavior of the DSS. You will not believe it's not the first time. There was a time there was also an issue in Ile-Ife in which some high chiefs were arrested in Ile-Ife and taken all the way from Abuja. He took the outcry of the Afenifere and the Yoruba leader before these people were brought back to prison. And then you now also have Sowore, and then again you are now having the Igboho lieutenants being taken to Abuja to be tried. How many times have you seen them arrest Boko Haram bandits and bring them to Abuja to be tried? How many times have you seen them arrest bandits who kidnap people and all that, and then they are taken to Abuja to be tried? Even when Sasaki had his issues and all that, he was probably taken to the federal high court, Abuja High Court, a court in Kaduna State where he allegedly committed the offense, and then he's tried. And so these are the issues which we must all address as a nation. With regards to the bail, just a few minutes, I have read the bail conditions, and I also want to say that the bail conditions are too stringent, and it's totally alien to our laws. And you look at section 136, which talks about fair hearing, and section 165(1) of the Administration of Criminal Justice System. If you will permit me, I will just quickly go through one portion of that. That portion of the law. It says the condition for bail in any case shall be at the discretion of the court with due regard to the circumstances of the case, and shall not be excessive. And shall not be excessive. So when you ask people, the defendant, to provide a civil servant, he is on this level, somebody who has a property in Abuja. And 5 million bail bond.
For 8 of them, why 10 million for 4 of them?
For them. Look at the kind of people that have been tried. Where are they likely to be able to get such persons who will provide all those guarantees that the court is asking for? Invariably, the court is not too disposed into granting them or into allowing them, wanting them to be able to perfect their bail in good time and then to be able to go home. And I also refer you, there is this authority, Ogwefi and the state. It's a very old case here, 2000 and now. 5 weekly reports of Nigeria. And a key person is not in jurisprudence. A person presumed to be guilty, but he is given the benefit of being innocent until the contrary is proved. This presupposes that he is not to be banded or be punished or remanded in custody for an unnecessary long time without reasonable cause to defeat the cause of justice. Even more pungent is the position of Honorable Justice Oduneye in Fela Anikulapo Kuti and others versus the Commissioner of Police. It's an unreported case. Justice Oduneye said, all too often, the prosecution prefers a serious charge in court against a suspect merely to ensure that the court does not grant bail to the accused. However grievous the charge may be, it ought to be borne in mind that is mere allegation, and suspicion of commission of an offense cannot take the place of a legal proof. It is on the basis of some of these authorities that I am of the opinion that the bail condition that has been given to this Igboho's lieutenant is excessive and then the lawyer should file for immediate variation of those bail conditions, and that the case should be transferred to Oyo State Federal High Court for trial. Trying these people in Abuja for offences that is allegedly committed in Oyo State and all that is a technical way of emasculating and denying these people the opportunity to robustly defend whatever allegations have been brought against them before the Federal High Court in Abuja.
Okay, Honorable Kabi, looking at the fundamental human rights being filed 32 days after, if at the end of this matter they are let go by the court, they are acquitted, who pays for this period that they have suffered?
The problem in Nigeria is that should I say we don't have law, or that we have laws that are not even effective? we are not in shortage of laws. There are laws upon laws upon laws, but all of them are not working. For instance, there are some agencies of government that you just see they establish. There is no need for them. All these things that the DSS are doing, we have the Department of the Secret Police.
Exactly.
In the police side,
the criminal investigation department.
They don't wear uniform. They can do all these things.
Exactly.
Whatever the EFCC is doing, we have special fraud unit.
Exactly.
The SFU to track it. Whatever ICPC is doing, they are doing it. Whatever the traffic warden police are doing, the road safety, they can do what the road safety is doing, but we just proliferate all these things. Now, to go back to the question, some of these things, when you look at it very well, you sometimes I wonder how the whites, the advanced country wives, how they will be laughing at us first of all. In my opinion, even the bail itself is illegal. Okay. It's illegal. There is no basis for them to be granted conditional bail.
Exactly.
These people, the court by itself, has shot itself on the leg. That there is no charge. Upon what basis now are you granting bail? Bail for what offense? You have not committed any offense, for goodness sake. What the court ought to have found is that they have been unjustly arrested. Exactly. They have been unjustly and illegally detained. Now in law, under fundamental rights, if you are detained, once it is established that your fundamental rights have been breached on the authority of Onogoru, there is this Serkin, whatever, during Awolowo time, that it is presumed. Okay. Once it is established that your fundamental, even when you are not asking for damages, the court will grant it. But unfortunately, who bears the cat? You will only get the damages, it's only by word of mouth. You will not be able to enforce it. As a human rights activist, I know very well, as of May 2015, the damages the Nigerian police was owing Nigerians for violating their fundamental human rights was 28.something billion. I have not followed the trend since then, because the human rights violations under the government is worse than under a military junta. So from 2015 to today, I don't know what it could have been. So this is the situation. If somebody has not bail, is that the essence of bail. If you want, there's the case of the judgment of Justice Bello, where he said the essence of a bail is not to release the accused person, but to give him time to go home, to be able to come and answer for his offences, and that as a Nigerian, he is free to breathe Nigeria here, he is free to walk freely on Nigeria road, and in the judgment of one court of appeal decision, that giving a bail to an accused person on very stringent conditions is like putting a sumptuous meal in front of a visitor, and you tie his hand not to eat it, because what you have given by the right hand, you are withdrawing it by the left hand. Because now, if somebody has not committed an offense, the court has no jurisdiction, in fact, to sit over that matter. And again, to come to what my learned friend has said, I agree with him completely. There is only one federal high court in Nigeria that operates one jurisdiction, single jurisdiction. However, a practice has snowballed, a practice has developed and has evolved over the years, and there are practice directions issued by the Chief Judge of the Federal High Court, and the practice that has evolved is starting from the case of Patrick Njobe and the state, that when the initial offences started from here, and you consummate it in another state. You started in the first state, you consummate it in another state. This place can have jurisdiction. Now, what are we trying to say? When you talk about territorial jurisdiction, has evolved. Now, you cannot date somebody that has committed an offense in Lagos to Abuja for one, except you have an ulterior motive. And if you are talking to the DSS who can, effectively superintend over this, we have DSS department in Lagos. They have presence in all the states of the federation. They can easily communicate with the headquarters for easy question. So why are they in Abuja? So if there's no offense at all, what the judge ought to do is to release them unconditionally.
Exactly.
For him to now say to come and do what? Because bail is that your case has been adjourned to so day in future. Come back on that day, get a surety. So why the need for the 10 million, 20 million, 50 million that they are
there's no case before?
It's total rubbish.
Okay, we are still coming to that. We have a guest live from Abeokuta, Barrister Olubayo Duro, Barrister Olubayo Duro Jai. I guess you can hear me, Barrister. Yeah. So, what's your opinion? What's your opinion about this bill? The bill giving bail condition. The judge said no charge had been laid before the court. What's your opinion on this?
Thank you. Good afternoon to Nigerians, and I want to say good afternoon also to the guests in the studio. I cannot agree less. Especially in respect of the submissions made by the guests in the studio. When there is no charge, when there is no substantive charge, a case against a person that is called a suspect, I wouldn't know the reason why the court had said they were granted bail, because the DSS had not at any particular point in time preferred a charge against the suspect. And let's even agree that they were given bail in court based on what? Because ordinarily when a person is granted bail in the court, it is based on the fact that there is a charge that is preferred against such a person, and because of that, in order not to trample on the rights of that person, the person is entitled under the law, constitutionally, to be permitted to go and live, within the provisions of the law in the society until that case is determined. So the present case we have at hand, the DSS had not preferred any charge, and the DSS had even acted, which has always been the situation in Nigeria, acted in such a manner as if they do not obey or believe or submit to the jurisdiction of the court. Before the DSS arraigned this suspect, it took about 34 days. And the question you ask yourself is, there was no charge preferred against them. They were arrested and they were put in custody. And the question is, do DSS have such a right to do that? Arrest people, you don't have any charge before a court, and you keep them for 30 days. And it was about until after 34 days that they brought 8 to court. The court had to ask them to bring the remaining 4. They were 12, and they brought the remaining 4. And the 12 suspects were granted bail by court. Like I said, I agree hook, line, and sinker with the submissions of the guests in the studio. There is no way you will say you are granting bail to a person that has not committed any offense, or that any offense has not been preferred against. So, but whichever way, in the wisdom of the courts, because of the circumstances, the court has decided to grant them bail. It is now for them to go and perfect that bail and enjoy the freedom pending the time the case is determined. Also, I agree with the fact that sometimes the bail conditions granted to suspect in court sometimes is such it's not so interesting, because you ask yourself, by the time bail conditions are granted to suspect in court and you look at the offense committed, you ask yourself, does it worth it? Because the provisions and the guarantee of the Constitution is that pending the time the court is able to say that you are guilty of a particular offense, then you can enjoy liberty under the Constitution. So sometimes, and most of the time, when we see courts granting bail on stringent conditions, we are mixed. Sometimes we look at it, why should it be like that? Is it that the court also does not support the respect? We can't say the court does not support the rule of law or obey the rule of law, but sometimes we wonder why courts go to that extent to grant bail to suspects and such bail conditions, and as such that you may not be able to perfect such bail conditions on time. And invariably, it keeps those suspects in custody for a very long time. And at the end of the day, sometimes you even have to bring an application for variation of bail before they can actually enjoy those conditions of bail.
Yeah, Barrister, yeah, we are still with you. Barrister Olubayo, yeah. He said something now. I want us to look at, because the DSS counsel had sought the leave of the courts. He wanted to extend their detention, but the court refused, since no charge had been brought. Now, does our constitution support a suspect to remain in detention while investigation is still ongoing, or you conduct all your investigation before you arrest the suspect and charge the suspect to court?
Yeah, honestly speaking, I will take my cue again from the Hush Puppy case. I mean, look at how many months and years it has taken the American FBI to investigate Hush Puppy, put all the pieces of evidence, whatever they may have, together before they now went for his arrest. Unfortunately, the opposite is the direction. I mean, is the case in Nigeria. It is after the police, the DSS, or the army, or whatever, immigration, have arrested you that they will now say they are investigating. In fact, most time when you go to court and then you apply for bail for the defendant, they will say no, investigation is still going on, and that the defendant might tamper with the process of investigation. That is also alien to our law. You are supposed to have concluded your investigation, arrive at a very convenient point in which the constitutional provision that says within 48 hours where there is no court within jurisdiction, you bring the person to court, you will be able to meet it. If you will not be able to meet all those constitutional provisions that say within 48 hours, a suspect should be brought before the court, then you don't go for him. But here the opposite is the case. They will rather arrest the person, put him in custody. In fact, most times, our security people don't investigate any case. They merely rely on torturing people, and after they have tortured people, they force you to write some statement. Exactly. And then they go to court. That is the one they will now be brandishing. He has made a confessional statement, my lord. And then there is no need for all manners of things. It's alien to our jurisprudence. But lawyers times without number have made efforts to ensure that the procedures are followed to the letter and order. But you find out that most of these security outfits still defy the court. You saw what happened even in this Igboho Sunday, I mean, lieutenant's trial. How many times the judge had to repeat himself that, look, bring these people to court. And then the DSS was now arguing on semantics, the spelling of certain names, the spelling of, when in actual fact, when you arrested these people, you paraded them. They were 12 and you paraded them. There is no ambiguity or any confusion whatsoever as regards the people that are arrested. And so if the court say bring the people that are arrested in Sunday Igboho's court and order, what argument are you now making with regards to the spelling of name and what have you? And in actual fact, the way a Yoruba name is spelled in Edo State might not be the same way it is spelled in Edo State.
That's true.
I know that. So these are part of the executive rascality, especially that we have begun to see, or that we have continued to see over time. But you see, in a way, I would want to blame, with due regards to our lords who are doing very beautiful jobs in all the respective courts and order. I have argued before many of them and said, look, when you give an order and then the security outfit or the security arm of government disobey that order, and they still have some other cases in your court, why do you avail them the opportunity to continue with some of these other cases? Why don't you say go and comply with my order first? And after you have complied, then we can also now begin to look at some of these other cases in court. But too many times the judiciary or the people on the bench also will not want to offend the security people. Maybe because of the nasty experiences some of them have had in the past.
You will
recollect the first branch arm of government that executive wanted to silence was the judiciary, and so they went into the homes of judges in the middle of the night and then raided and then treated most of them like a common criminal. Yeah. Not too long ago, I think a judge in Akwa Ibom or thereabout, I've forgotten the state now, was retiring and came out publicly and said, look, the DSS has been on his neck day and night. They will put people in front of his house, and those ones have been harassing and intimidating him simply because he gave a ruling that was not favorable to the people in authority. And the man said he has had to go and buy out of his retirement benefit to go and buy his coffin and put it in there because he doesn't, I mean, the harassment he's getting from the DSM might either lead to an heart attack, a stroke, or whatever. So when you see that kind of intimidation going on all over the place and all that, except you are a very, very strong person, most times is that you want to tarry a little bit when you are dealing with the cases that involve some of these security, because they have over time proven themselves to be lawless, reckless, and then behave like the criminal that they're supposed to be arresting and then investigating and then prosecuting.
Barrister Akabil, I believe that when a judge gives an order, the order ought to be obeyed according to the constitution of the land.
Of course.
I remember on Monday when they produced the associate of Sunday Igboho, they brought just 8 of them instead of 12.
Yes.
What can the court do to stop these excesses by law enforcement agencies?
The court,
that when they give an order, they should carry it to the letter.
The court, like Nikki Toby has said in one of the judgments, that well, the court has no money. But the only thing the court has is their orders. And that when these orders are not obeyed, then it becomes something else. In fact, it is a threat to the very root of democracy. And now, if you have given an order, and as a judge, if you have, and the same authority is coming to you, you have the duty, you have the power, you have all the means in the whole world to sanction them, because whatever the judges say from the bench is law. That is why the realist school of thought in defining law said law is what the judges say from the bench. Now you can say, okay, you can't detain somebody, blah blah blah. It is the judge that will now interpret it to be so. Now I have seen a situation under a military government, I think in this Lagos state, where a judge gave an order and they didn't resign, and he resigned. I will not live to see my order being disobeyed. But we don't have people with principle again. The problem with our democracy, the problem with our rule of law is from we lawyers and the court. The court and the lawyers, we are partners in progress. And except we work together as one, we may not get anywhere. The Bible said a house that is divided cannot stand. Because you see, sometimes on what basis will a lawyer take an adjournment of 3 months? On what basis will the judge even grant such an adjournment? The Ministry of Criminal Justice Act has said you will not have more than 3 adjournments, and you were done even a corruption case. You were done it for 3 months. In China, when you embezzle money, public fund, it's public execution. But in Nigeria here, they treat you like a king. You will even, take people from your village to come and sing, and the court will be looking.
Money laundering.
You understand? If I were a judge, I see some people singing, I will order for their arrest and detain them. These are the things court can do, but our courts are weak. That is just the problem.
Okay, Barrister Olubayo, just one last thing before we move to the next topic. What is your opinion about this?
I agree totally with the submissions of guests in the studio. You see, the truth of the matter is that we have a lot of challenges in Nigeria, and especially when it comes to administration of justice. And if an ordinary man or a citizen of Nigeria cannot get justice, then what is the purpose of law? What is the purpose of having law enforcement agents? What is the purpose of having the bench and the bar? And let me quickly say this. Really, I learned when I was growing up that in those days, you don't even, for any reason whatsoever, thought when you are passing through a court premises where a court is situated, or even a lawyer's house or a judge's house. But we see that today a lot of people defy even orders from the judges. The judges will specifically direct and give, and this comes most especially from law enforcement agents. And one of the challenges we have here that I even ask myself questions over and over is that, does it mean that law enforcement agents in Nigeria does not even understand the meaning of constitution or human rights or law? Because by the time you go to court and you disobey courts, these courts are human beings. Like one of the guests rightly said, they have their reasons why sometimes they have to apply wisdom, even when they give order and law enforcement agents disobey those orders. It's because there are sometimes aftermaths. After God, we are made known to know that judges are the next. But where is that sanctity today? Where is that respect? Where is that fear of the court? A lot of enforcement and law enforcement agents, our DSS, the police, the FCC, they do whatever they like, and they bring to court flimsy excuses. And these days we look at it. Why is it that court does not have that will to exact that power that has been given to them by the Constitution on some of these law enforcement agencies? So I will submit by saying I believe that we still need to do a lot between the bar and bench. I know in most of the states in Nigeria, we have what we call bar and bench forum, where judges and lawyers come together and reason. And I believe that this avenue is supposed to be for law reforms, where we discuss issues that touches on law, on judges, on the bar, on the bench. So I'm believing that in the nearest future, the law enforcement agent will understand what we mean by having a constitution, respect to our constitution. They will understand what we mean by having human rights laws. And let me say this also. Most of the time, when some of their cronies, when some of their allies, when some of their friends and families are in this kind of trouble, they don't dare do what they are doing to common men who does not have any other person. So when those of, just like a very good case, what we are talking about, the Oshkopi case, because it could pay so much, they were able to put somebody in custody without no petition, without no allegation, for so long, for almost a month. So we need to rise, lawyers, bar, and bench, to this task and ensure that at the end of the day, Nigeria is safe from the hands of gun-carrying agencies in Nigeria.
Before we move to the next topic, this about 72 hours after the bail was granted, but yet they are yet to perfect this bill. And I learned that they are soliciting funds for the perfection of